Hello, and welcome to this special edition of Amicus, recorded live at the WBUR Festival in Boston. I am Mark Joseph Stern, co-host of Amicus with Dahlia Lithwick, Slate's podcast about the courts, the law, and the Supreme Court. And as listeners at home heard at the top of this week's episode, we are entering what we at Slate like to call Opinion Palooza, the final weeks of the Supreme Court term when the justices issue decisions at a head-snapping rate. Why? Because they hate us, and also because the justices are very keen to flee D.C. on their billionaire buddies' private jets, so they dump a bunch of huge opinions in our laps at the last minute, and we, your humble Supreme Court watchers, must forego sleep and any semblance of a normal life in the month of June to report on it all. Which is near impossible, but that's by design. Then, while the justices live it up on their BFF super yachts, the rest of the country has to deal with the fallout. But this Opinion Palooza will be different from the others. It'll be different in part because of the actions of the President of the United States, whose barrage of executive orders continues to result in frenzied litigation in the lower courts with an unprecedented number of rulings against the government, prompting the Trump administration to demand emergency relief from the Supreme Court on what we call the shadow docket. It's also going to be different because of the consequences of the Supreme Court's own actions, which constructed the legal reality that paved Trump's path to a second term and justified his ongoing seizure of unlimited executive power. Which brings me to our guest, who has been thinking and writing about presidential power, the Constitution, and the executive branch in ways that I don't always agree with, but that always make me think about it more deeply. Jed Shugerman is professor of law and Joseph Lipset Scholar at Boston University School of Law. His forthcoming book, tentatively titled A Faithful President, The Founders versus Royalist Originalism, questions the Roberts Court's evidence for its theory of unchecked and unbalanced presidential power. Jed has written numerous historical/originalist amicus briefs, including cases on presidential power, the Emoluments Clause, and an upcoming originalist brief defending birthright citizenship. He considers himself an originalist, at least in theory. Jed, welcome to Amicus Live at the WBUR Festival.
Great. Thank you so much for having me.
Okay, let's start with the simplest of table-setting questions. What in the world is the Unitary executive theory?
Great. Well, the Unitary executive theory, on one glance at it, is a simplistic truism. I mean, no one thinks there's more than one president, right? So it's clear there's a single president. The question is the unitary. Really what they mean is unifying under a critique or rejection of the administrative state, right? It's to unify all executive power under the president against what conservative originalists reject as what they call an unconstitutional fourth branch of government. That's one origin of it. Okay, so one way to put it is I'm paraphrasing Jack Goldsmith's summary of these cases, that the president is an entire branch of government. The president is the executive branch. Everyone works under everyone in the executive branch works for, is under the control of, and is removable by the president.
So I want to get to why that's just wrong as a historical matter. But before we do, can you sort of remind us how the Supreme Court has specifically used this theory to empower Trump? And we only have an hour for this whole event, so maybe sort of, condense it into a couple of highlights or lowlights.
I'm gonna summarize it in a big picture way, and then we can go back and double click on these steps. I call this heads I win, tails you lose originalism. The heads I win. And in some ways, it is the head of government. It's the crown. It's a first assumption without evidence, in fact, contradicted by historical evidence, that the president has explicit and the key thing is implicit powers from the Constitution under an interpretation of what executive power is. It's an assumption that executive power has traditional and even royal meaning. That's the heads I win, right? That's the royal crown. The tails you lose is the step of saying, okay, the separation of powers is formal, which is also, as an originalist matter, wrong. But that because there's a formal separation of powers, any power that the president has implicitly or explicitly is unconditionally the president's. And this is also against the historical evidence. Okay, so after those first two steps, then the third step is then putting all of that on steroids in Trump versus United States. Okay.
And that's the decision granting Trump sweeping immunity from criminal prosecution.
That's the immunity case. That is, it is totally ungrounded in originalism.
And let's just get into it. Why? Tell me.
Okay, sure. So let me double click on those first two steps. Okay. Actually, all three steps are massive originalist problems. Okay. So the first step is the assumption that executive power implies a whole panoply of prerogatives. Right. So where do they get this from? I'm going to go back 100 years, almost to the year of a decision called Myers versus United States, where Chief Justice Taft, you might not every listener knows Chief Justice Taft because they know of President Taft. So after he's president, he gets nominated as Chief Justice and puts a thumb on the scale for presidential power. Maybe he was bitter that he didn't get all of his agenda through because he didn't have enough power. So, and also behind the scenes, as he's writing this opinion, he's persuading his judicial colleagues who are from the South or Southern Democrats that these checks on the presidency came from an era of radical Republicans who defended emancipation and defended black civil rights, and he uses that to taint these restrictions on the presidency. So he's behind the scenes making white supremacist arguments for presidential power. That's part. Other historians have identified that. But the argument he makes in that case for removal power is that the executive power implies royal powers. Right? That's royalism. That's the heads I win, and he has no evidence from the founding that the founders meant for this. He just assumes that executive power. So what you learned in fifth grade turns out to be true, or AP US history. The revolution was against primarily executive power by the king and by royal governors. There's been no historical evidence that should make anyone doubt that that was a main point of the Republican. That's why it's a Republican era. It's anti-royal. Okay, that's step one. Then step two, that more comes about because of the Roberts Court before Trump. So just to be clear, this is a case when Obama was president, a case in 2010 called Free Enterprise Fund. For the first time, the Supreme Court says that not only does the president have a power to remove, it is indefeasible, which means unconditional by Congress. How do they get there? This is by supercharging separation of powers. It's an assumption, again, without historical evidence, that the separation of powers, though a thing, is a formal thing. So that any power that the president has is unconditional, that Congress can't set conditions like good cause or inefficiency, neglect of duty, or malfeasance. Those conditions that would still give the president removal power, but under conditions, that violates this manufactured formalist version of separation of powers.
Okay, so I guess before we get to the next step, what you're saying is basically we had for many centuries in this country a system where the executive branch was divided. There were checks on the president. There were other executive officials who could not be removed by the president except for sometimes good cause. And that ensured that the president himself was not consolidating too much power, that we remained a democracy without a king, which, as you say, was seemingly one of the goals of the revolution against an actual king that we went through to establish America. Then comes Chief Justice Taft and his white supremacist Southern colleagues, and they collectively decide that they don't like the idea of checks within the executive branch. They don't like the idea of checks on the president. They think that the president is an entire branch unto himself.
That's right.
And he holds 100% of the power. And so they decide to start ripping up all of this sort of historical precedent and tradition that had allowed Congress to impose conditions on the presidency, in part part to ensure that the president didn't become too powerful and start to look like a king, like the king that we overthrew in the revolution. And so the Supreme Court really, and this is 1920s.
Yes.
The Supreme Court is really kind of undoing a key facet of the American Revolution itself, it seems, by going back and sort of reestablishing a king-like president who has this, like you say, indefeasible power over the entire executive branch to do whatever he wants, remove anybody he wants, because he is effectively the monarch, not just the elected leader.
That's right.
Is that a fair summary?
A totally fair summary. And I just two additional points to that. One is what I mean by the heads I win, tails you lose is that when it's convenient, the Supreme Court will just cite English history and practice like monarchy.
Yeah.
But the tails you lose is an assumption that the founders were rejecting the 100-year tradition that led into the American Revolution of legislative supremacy, or at least legislative primacy. They assume without evidence that the flip side, that Americans were rejecting English systems and English practices. You can't just have one and then assume one and assume the other. You need evidence. That's one thing. The second thing is, just to piggyback on what you were saying, that this goes all the way back to the founding. A number of historians, I'm part of, let's say, a half dozen to 10 historians who in the past decade have just been digging into these assumptions. And we keep finding overwhelming evidence that this goes all the way back to the convention, the ratification debates, and the first Congress. This was disunitary. There was a separation of executive power from the beginning.
Okay. And just a little side quest here.
Yes.
When you present all of this evidence to the Supreme Court saying your theory is wrong, your history is wrong, you don't have the tradition right, here's hard proof that you've botched this, what has the Supreme Court's response been?
Justice Kagan loves our evidence. In dissent.
Okay.
In dissent. So this was not presented in the case I mentioned in 2010. So what happened is this was all what some people call the Constitution in exile. What I mean by that is there were a series of theories that conservatives had held on to from the New Deal to the present that were the critique of the New Deal administrative state. So let me re-articulate this just to be clear. This theory gets recreated in the 1980s. It first is in Nixon. So I first found it in Nixon's defense lawyers' briefs. Right. So it basically goes away. It goes away from the 1920s because then 10 years later, not only is this an anti-royal move, the separation of executive power then gets recreated or re-embraced by the Supreme Court in a unanimous decision by conservative justices in response to totalitarianism. So they see the New Deal and they think we need to make sure that there are checks and balances on executive power. So this is 1935. This is a case you may have heard about called Humphrey's Executor. That is part of the administrative state separation from presidential power in the context of the abuse of executive power in the 1930s. Okay, so that's part of the background. But then, as we've gone back and prompted by the fact that Chief Justice Roberts, and in a 5-4 decision, went back and invented history to recreate this unitary executive theory, we've been presenting this evidence, and it has been only embraced in dissent. And this is a crisis for originalism. Right, originalism is supposed to look at historical evidence and take it seriously, as opposed to what I call stare errata. Like, people have heard of stare decisis. Stare decisis is preserving the decisions. The Roberts Court in these decisions has engaged in stare errata, which means protecting the errors. They've made historical errors, and they just cite those errors like they did last week.
Okay, so let's sort of take this down from abstraction to a little bit more concrete of a realm, which is Donald Trump is now the president. Again, as you say, the Roberts Court has been setting the stage to dramatically expand executive authority. One of the few things boxing in Trump, at least in theory, was this decision you mentioned called Humphrey's Executor from 1935, where the Supreme Court rolled back its obsession with making the president a king, right? This was a decision where the Supreme Court said, actually, we don't think the president is a monarch. We're going to allow for checks and balances within the executive branch. We're not going to, just elevate him to the kind of level of the crown that Chief Justice Taft wanted to do. And I mean, that decision reigned supreme until about a week ago, right? And so maybe sort of walk us through, well, first walk us through like the more recent history of the Supreme Court rolling back these precedents, Humphrey's executor,
right?
And then maybe get us to how Trump versus United States, in a way, kind of put a nail in the coffin.
Right. So the Supreme Court, in 2 decisions, was very careful to say we are not calling into question everything. We are doing a narrow thing here. Right. What I mean by that is, in 2010, the case I first mentioned called Free Enterprise Fund, it was a very specific kind of structure that they identified and narrowly overturned. And that was, to put it as in simple terms, it was a particular board with 2 layers of protection. That they were under the SEC that has implicit protection from presidential removal, and a board had explicit protection. Still, just good cause, not denying the president had that power, but it said that those 2 layers of conditions was too much. But they dropped a footnote. In fact, footnote 10, if you want to keep score at home, where they said, we're not striking down all of these 2 layers. We're just pinpointing this. I'm paraphrasing. So then 10 years later, with Trump in office, in a case called Saylor Law, they pinpointed another specific structure. These are not like the Fed is a commission of bipartisan staggered commission. Those are the independent agencies that Humphreys protected. They distinguished the CFPB, the Consumer Finance Protection Board that Obama had created, that had a single head of an entire agency. And they said that's a problem. So just to be clear, it's not that any prior precedent said that Humphreys and that larger precedent's in trouble. In fact, they said, we do not touch Humphreys today. So on paper, the Roberts Court has said we are leaving this precedent in place. And regardless of what's said at Federal Society conferences, which I attend, about speculating or thinking we have a theory here, the chief executive, the President Trump, disregarded that precedent to fire a series of officials.
Okay, so now let's come to this, right? So Trump is in office. He stormed back into office, embracing fully the Unitary executive theory, deciding, I am going to use this to my advantage to take total control of the executive branch, because he felt that one of the key factors holding him back in his first term were these officials who were sort of left over from the Obama administration, who maybe hemmed in his agenda a little bit. So Trump fires a member of the National Labor Relations Board. He fires a member of the Merit Systems Protection Board, agencies that protect unions, agencies that protect federal workers. He basically paralyzes these agencies, takes total control over them, and does so illegally. Like, just to be totally clear, Congress said he could not do that. Congress enacted laws saying you cannot fire these people without good cause. He fired them without good cause anyway. That was lawless.
So I'll even be more precise about that. After that, he fires commissioners who are part of the Federal Trade Commission. Humphrey's executor was about the Federal Trade Commission. So we don't have to speculate about what other commissions are protected. So in defiance of both the first branch of government, Congress, and in defiance of the third branch of government, the courts and their precedents, he fires those officials on his own, and I'd say it's lawless because he was disregarding judicial decisions. And let me just note, this is a particular moment. Like, how about Roberts Court? Let's read the room. Like, let's not lose the plot here. This moment is the time where there is so much question about whether this president is faithfully executing the office and is obeying precedents. And now the Roberts Court is saying, oh, these people you fired when it was lawless, we will retroactively green light. And we know where that leads for someone like Donald Trump.
Okay, we have to take an ad break now, so I'm going to read that. We're going to take a short break. And we're back. Amicus is live at the WBUR Festival in Boston, and our guest is Boston University School of Law professor Jed Shugerman. So, just to pick up on what you said before the break, Trump illegally fires these individuals. They are not allowed to be fired. Sorry, hold your mic to your face. I'm getting a note, just a little. Yeah, when you talk. Yeah. Trump fired these individuals. They're not allowed to be fired. but the Supreme Court allows him to do it anyway. And that's what happened just last week. And so now we have essentially the first unitary executive maybe in history. Trump has taken advantage of the Supreme Court's latitude and generosity and beneficence, and they've just rewarded him for flagrantly breaking the law.
That's right. And this is not just me. I mean, Justice Kagan puts this in her dissent in this remarkable case. This was not a case that was on the docket. This is what is either called, I think, the shadow docket is one way to understand it. Professor Dan Epps calls this the lightning docket. And these are cases that happen out of one kind of emergency or the other, as opposed to COVID, which was an external emergency. The emergency is Donald Trump, right? So these firings did not proceed by normal legal practice. These cases came up because lower courts said, let's pause here. We have this. And let me just say it again. This Humphreys executive precedent is a unanimous precedent from a majority conservative court, right? And instead of waiting for briefing on this, the Supreme Court then reaches out and overturns the judicious stays when nothing huge is at stake. There's no emergency in whether these commissioners stay in office for another 9 months, right? So they reached out, and why did they do this? I think I'm going to make a connection here between the way other legal actors, like the law firms that are pre-capitulating to Trump, that's kind of what the Roberts Court did. It did not have to do this move. Certainly, and I'll say this, I am an originalist in theory. My originalism in theory is being tested by the pseudo-originalism and impetuous, injudicious moves of the Roberts Court, because I think what they were doing is trying to split the baby. Like King Solomon only threatened to split the baby, knowing that splitting the baby, neither mother nor baby is happy when you actually split the baby. But that's what the Roberts Court did. They split the baby by cutting loose the rest of the administrative state that they don't like. And because they wanted a way to publish with a way to get Trump to buy it, the protection of the Federal Reserve and the protection of the capitalist version of the non-unitary executive.
Right. And I mean, so you're getting to what's maybe the most bizarre feature of this decision. And there are many bizarre features. The Supreme Court essentially overturned a 90-year precedent on the shadow docket. Didn't have briefing, didn't have oral arguments, just said, we're not going to protect these people from an illegal removal, rewarding Trump for breaking the law.
That's right.
But then, while seemingly embracing the unitary executive theory, randomly established a carve-out for the Federal Reserve, saying that, oh yeah, okay, Trump can fire all these other people, but he can't fire the chairman of the Federal Reserve or members of the Federal Reserve Board of Governors, because why exactly?
I don't know. It is this decision on the shadow/lightning docket was 4 paragraphs. Those four paragraphs were really just 2 sentences. The one sentence that was at the lead of the opinion was the heads I win argument that I was describing before. Because the president has the executive power, the president must have the power to remove. Okay, that is giant question begging. Like that means you're assuming that the executive power includes the power to remove. That is, and if that's true, why isn't that also true about the Federal Reserve's executive power? So this is the sentence that comes up later. I've just pulled it out because it's just so bonkers. This is the sentence. The Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States, citing their own case that didn't say any of that 5 years ago. They cite Saylor Law. Now, not just Saylor Law, they cite a footnote, keeping score at home. That's a footnote number 8 that doesn't say any of that. So not only is the Roberts Court, which claims to be originalist, not citing any historical evidence, not citing any historical article for this proposition, which turns out to be wrong. They're not even good precedential lawyers because their footnote doesn't support this. So just one more beat on this is the Federal Reserve is not quasi-private. The Federal Reserve Board, though it has regional banks that are quasi-private, the Federal Reserve Board is public and engages in public executive power. So it's false as a matter of 2025, but it's also false as a matter of its description of the first and second bank, because those were private. And let me just say one more thing. An originalist will tell you, right, who's serious about the history, the first bank was a private actor that exercised executive power. which by itself is a contradiction. This Roberts Court, in this sloppy 4-paragraph opinion, contradicted their own theory because they just told you, without meaning to, it is okay for private actors to exercise executive power. That contradicts the claim that the president holds all of the executive power.
And also, I mean, so their reasoning is almost a tautology. And they say the Federal Reserve has a unique structure and a distinct history. Doesn't every agency have a unique structure and a distinct history?
Totally.
How does that give us any kind of historical basis for carving out the Fed from Trump's reign of terror over every other independent agency?
So first, I just want to say people should go back and listen to, your interview immediately after this case with Dahlia. You made that point.
I was so incandescent that I don't know if I was really lucid in that description. So I'm trying to give it another pass now.
I will say incandescent was more, when we say like more light than heat.
Yeah.
That's a good thing.
Well, you wouldn't accept this on a 9th grader's history
That's
report.
correct.
But we're getting this slop fed to us from the United States Supreme Court, and we're supposed to pretend that they're still doing law. And for people in our position, it's increasingly difficult to uphold that pretense with decisions like this, right?
So let me say two things. One is, I think you're right that different commissions have different structures. Yeah. In this case, this is really wrong as a matter of administrative history. The Federal Reserve was built, and I've done this work, other people have done this work too. There were the commission, the nonpartisan staggered commission, is a structure that Humphrey's executor approved of, not because the FTC and the Fed were both built on that structure in the same 2-year period on prior models. So it is actually quite false to say that there was something particularly unique about the structure. But let me say one more thing about that history point. I, as an originalist, am increasingly feeling embarrassed. I mean, maybe there's always a level of embarrassment with what originalism looks like in practice, but the history in this case is so clear and overwhelming that it is now, I think, an embarrassment because the Roberts Court needs to remember that people read, right? People will read the dissents, people can read our articles, and it delegitimizes the entire Roberts Court and the rule of law for the Roberts Court to do what it's doing.
So I feel like we could go on for ages about all of the history that's made up and fake and all of this slop. But I want to sort of raise like a practical point, which is of all the times in history for the Supreme Court to be embracing essentially an unlimited vision of executive power, where the president just has dictatorial control over the entire executive branch, where there are no more independent agencies, where he can fire members of the FTC and weaponize it for his own partisan agenda, whatever, that this is the last president you would ever want to hand that power to. Maybe Richard Nixon is a competitor, right? But like, this is just the last guy who I think anybody who cares about like American democracy would want to hand over the keys to an unrestrained executive branch to. And so do you think that the court is doing this because they love Trump and want to crown him King Donald? Do you think the court is doing this because they have a majority now, so they're just going to smuggle it through and get it done while they can and let the chips fall where they may? Why is this happening now under one of the least restrained, least responsible, least civic-minded presidents that we've had in American history?
So I don't think they are doing this before Trump. I think they are bargaining in the shadow of Trump. I think this is what I think is they have been so ideologically committed against. So I think they worry about Trump, but they are more ideologically opposed to the New Deal administrative state. That and let me just say, like, this is like this opinion where they bend over backwards to invent bad history to protect the Federal Reserve. They're showing you the money. And by that, I mean showing you their right-wing ideological commitment to big business conservatism. So they are, and they think, and so that's why, so that's what I'm saying about where this theory gets revived. The theory gets revived in the Reagan administration as part of a deregulatory agenda against the administrative state. And though Trump worries them, they are more, and perplexingly in a time of tariffs that are also destroying the market, that this is also a bizarre time for them to be, and they're revealing just how much their ideological blinders blind them to the danger of Trump to democracy, but also the danger of Trump to liberal capitalism. I'm sort of a legal conservative, but I'm not a capitalist conservative. But if I were a capitalist conservative, I would be looking at this moment and say, now is the time to look back at the founders and understand that when they designed the Treasury and different financial institutions, Madison proposed an independent comptroller. The founders in the first Congress, they created a sinking fund because they knew they couldn't trust any singular executive power. It's not just worrying about Trump today. It's that the founders had this worry and concern about executive power from their time and the present. It is being a good originalist to say Trump is the danger the founders foresaw, and these are the rules the founders and past Supreme Court set against this particular danger, and they are so pro-Wall Street that they can't even see that Trump is a danger to Wall Street.
Well, except that that's why they carved out the Federal Reserve from Trump's reign, though, right? I mean, they're savvy enough to realize that if Trump takes control of the Federal Reserve, all of our 401ks are going to be in the toilet by 5 p.m., right? I mean, just to sort of draw this out, why the Fed carve out? Because then Trump gets to fire Jay Powell and start, slashing rates, and we're going to have Weimar Republic-style inflation, and it's going to be a disaster. And they know that, and we know that, and so they carve out the Fed so that Trump doesn't get his greasy little hands around that. But they give him control over these other agencies because, those agencies protect unions. They guard against monopolies and corporate power. They protect federal workers. And the conservatives don't want those protections to exist. They want protections for Wall Street. They don't want protections for everyone else. Do you think that's fair?
I think that's fair. And let me connect the dots to, I think, what we've been talking about, too, which is that the legal establishment can't grok. The legal establishment can't understand the threat of Trump, that they think they can make a deal. And so the law firms, so this is just the mindset of elite lawyers right now. They think that they can make deals and bargains with Trump, and they have ignored all of Trump's history where every deal is a deal he can break. So law firms pre-capitulate to Trump, thinking that, he'll stick to these deals. Universities pre-capitulate and acquiesce to Trump, thinking that Trump will stick to the deal and move on. So what is the Roberts Court doing when they split the baby? They think, Trump will only listen if we make a deal. We are going to pre-acquiesce. We're going to acquiesce to Trump's lawless firings, thinking that will preserve our good graces. Roberts got embarrassed at the State of the Union when Trump turns to him and says something like, "Thank you, I won't forget it." That should have been a moment where Roberts says, "My legitimacy is in the tank and I need to stand up." Instead, he falls in line with the law firms and says, "We are going to pre-capitulate on these firings and we'll make a deal." And that's this is the art of the deal with the devil, and it never works out.
I just sort of want to draw out something there, too. It's something Dolly and I have been discussing. It seems like the court thinks it can bless Trump's violations of the law when those violations coincide with the court's own agenda. Dismantle the New Deal? Check. Tear down the administrative state? Check. Kill protections for unions and federal workers? Absolutely. And then the court thinks that it can draw the line and enforce the law when Trump goes too far and presses in a direction the court doesn't like. Summary deportation of migrants without due process. They say, whoa, that seems a little too fascist, even for us. Right. We're not going to let that one go through without a little more due process. Or, but you can't fire Jay Powell, chairman of the Fed, because then we won't be able to pay full freight for our kids to go to Harvard or wherever they'll go now, Liberty University, I don't know. And it seems to me, you say the art of the deal with the devil. I think that's gotta be true. That then what happens when Trump does fire Jay Powell? What happens when Trump does summarily deport migrants without due process and the Supreme Court tries to draw the line and says, whoa, you can't do that? They've already set the precedent of blessing his egregious violations of the law. They have already shown that they will accept and embrace his violation of 90-year-old precedent, federal statutes, all of these things that they happen to dislike. So why would he pay attention to them and heed them and abide by their constraints when they decide to draw the line and he doesn't want to listen to them?
That's exactly right. And let me also point out that this is also where Trump versus United States comes into play.
Well, this is something I want to yell at you about, though, because
But wait, can I make the point and then yell at me?
Okay.
Which is the Federal Reserve protection. It's not a total protection. It is, again, good cause. So all the Supreme Court has said is that the Federal Reserve is a carve-out that the president has to give cause. Keep in mind, Trump didn't even attempt. I mean, this was the power play. Trump is like, I want this to be the fight, the culture war against the elites. I want to flex my alpha muscles. And I really mean, like, there is a kind of, gender performance of all of this where I don't want to even give a patina of good cause. But that doesn't, when the Supreme Court does the carve out for the Fed, on your point, what happens when Trump says, okay, you carved out the Fed that I need good cause. My good cause is the Fed is tanking my tariffs, or the Fed is tanking real Americans' economy. That's my good cause. Dare challenge my good cause. And that's where Trump versus United States comes in, because that's the third step, which is that's where it says, despite the fact that the Constitution has in it two faithful execution clauses, the president takes an oath to faithfully execute the office, and the president has a duty to take care that the laws be faithfully executed. That is not just a nod to God. That's not just religious symbolism, as much as I love religious symbolism, right? That's actual law, right? And that's where the Supreme Court has ignored the notion that the president has to show good faith, and you can't interrogate the president's motives. That means that when Trump does that, if he wants to fire the chief of Jay Powell, the head of the Fed, he can simply cite Trump versus United States again, as you've shown. They keep citing this as a get out of jail free card. It also is a get out of law free card. And that's where this is going.
Okay, so this is why I want to yell at you a little bit, though. Because I agree with you, of course, what you just said about Trump versus the United States. Again, this is the criminal immunity decision from 2024 that essentially thwarted special counsel Jack Smith's prosecution of Trump. Terrible decision. Really, Roberts used it to smuggle in so many of these ideas about the unitary executive that we're talking about, right? Because in order to let Trump off the hook for his crimes during and after the 2020 election, Roberts had to kind of embrace this dark vision of an all-powerful president who could wield the tools of his office for corruption and self-dealing, and that it would still be totally immune from legal scrutiny and even from congressional regulation. But you said, like less than 10 minutes ago, you don't think that these justices, the justices who joined Trump versus the United States, are doing this with the specific desire to empower Trump. And I guess, like, my question is, are you sure about that, Jed? Because if you read Trump versus United States, and I guess I have mixed feelings about this too. I don't think that any of them knew he would go quite this far. Right. But if you read Trump versus United States, it kind of reads to me, especially in light of what's happened over the last 5 months, like really setting the table for Trump to come in and just absolutely destroy all remaining checks on his power in a way that vindicates the most extreme and dangerous visions of the unitary executive theory.
I think they've been on this track for idiots. I'm not giving them credit for being originalists. They're being pseudo-originalists, and they would get a 1 on the AP US exam. Okay, but that doesn't mean that they're. So I think they are ideologically motivated. But I'm talking about faithful execution. I think it's clear that they've had an agenda since the 1980s. And I think there are several agendas here. One of them, now keep in mind, Nixon's lawyers cited these, like the vibe. These were like Article 2 vibes. My colleague, Christine Chabot, has that phrase. They've had, so what was that about? That was in the midst of Watergate. And I think most Americans' lessons of Watergate is that presidential corruption is bad. I think there is a cadre of Republican lawyers who cut their teeth. Scalia was in that holdover Nixon administration and Ford when he was cutting his teeth as a conservative lawyer. Their lesson from Watergate is congressional investigations are bad. Okay, so I think there is a revisionist history or a certain wrong historical lessons that they learned because they're so ideologically in favor of presidential power. From the Cold War, I think they believe that if, something about the Cold War was undermined if you didn't have total presidential power. Most of the unitary executive advocates, many of them are national security experts. And so there is a military-industrial complex agenda here. There is a culture war agenda. There is an assumption that the president is more in touch with real America, I say in scare quotes, and about religious and cultural conservatism compared to the fourth branch or the deep state. I think there are a number of. I think it's overdetermined why right-wing evangelical Cold War conservatives are ideologically in favor of presidential power. I think all of that came together in Trump versus United States.
So certainly these justices and these lawyers don't like the deep state. They don't like the administrative state. They don't like the fourth branch, whatever. It also seems like they don't care much for Congress. I mean,
That's
what
right.
we're talking about when we're talking about independent agencies, when we're talking about protections against firing, we're just talking about federal statutes enacted by our representatives in Congress to try to structure the executive branch in a way that doesn't lead us straight to a dictatorship. And the fact that the court, just a week ago and in so many other cases would blow past Congress's handiwork there with a wave to utterly bogus history suggests that they don't view Congress as a co-equal branch. They really seem to view the presidency as the apex of American governance. And Congress, you can take it or leave it. The removal protections are really just suggestions. And when they want to crown a king, they get to do it, even if it is King Trump.
Yes. So I love that you use the phrase co-equal branch, because it turns out other historians that I've been reading in the work on this book have exposed me to something I didn't realize before. The founders never used the phrase co-equal branch about the three branches. There's a reason why they put Article 1 first, and they spent so much time on it. It's because they were living in an era of legislative primacy. And the president, the part of the reason why there's a faithful execution clause is because there was a tradition of executive officers below the king who had to have fealty and faithfully execute legislation, and they had to defer to the legislative branch. That is the founders' design, was legislative primacy, not co-equal branches. So that is how the Roberts Court doesn't understand American history. It's because they think, this is an article that I co-wrote with Jody Short that identifies a historically false narrative where the Roberts Court treats the president as primacy, which is wrong.
Yeah, and just to spell that out a bit more, you're saying there's two faithful execution clauses in the Constitution. Right. They both instruct the president to faithfully execute the law. The law, in part, as enacted by Congress. But what the Supreme Court keeps saying is that actually that's not what faithful execution means. That, in fact, it's the whim of the president that he gets to faithfully execute. That if he doesn't like this person at this agency, he gets to fire them. If he doesn't like this modest restriction on his own power, he gets to blow past it. And that counts as faithful execution, even though it defies the will of Congress, even though it might bust a Supreme Court precedent from 90 years ago, because it's what the president wants, and ultimately that's all that matters. I mean, is that a fair description of what's going on?
And that's what happened in Trump versus United States.
Yeah.
Which, and let me just, this isn't just me. Justice Jackson and Justice Sotomayor nailed this, right? Sotomayor says there is a twisted irony in saying, as the majority does in the immunity case, that the person charged with taking care that the laws be faithfully executed can break the laws with impunity. Jackson wrote, after today's ruling, the president must still take care that the laws be faithfully executed, yet when acting in his official capacity, he has no obligations to follow those same laws himself. Not only is the Roberts Court in practice anti-originalist, they're anti-textualist. You don't have to dig into the history to know that faithful execution of the law is a signal that the president has to follow the law.
So final question. We hate curtain raisers at Amicus. We don't do them. We're not previewing the end of the term, but I did want to spend a couple moments before we go to questions from the audience, and I know you have a lot. Thank you for those. Just to hear, what are you looking for in both the argued cases and the cases on the shadow docket that you think might play into the dynamic we're describing? What is keeping you up at night outside the realm of the specific set of cases we just discussed that the court will soon be deciding that could, radically unsettle the law even further, as inconceivable as that might be?
It's birthright citizenship. And I used to think that this birthright citizenship case was a 9-0 slam dunk.
Not anymore.
Not after this decision yesterday. Not after this decision last week. This decision was procedural on the removals. The case that they heard under birthright citizenship was also procedural. They didn't hear the full case on the substance, but the decision was the consequences are enormous. In every district in the country do people who are citizens of the United States because they were born here under the original intent of the 14th Amendment's birthright citizenship, do they all have to lawyer up? And district by district, including districts that are rigged or stacked by Trumpers, do they all have to, in order to not be deported to Venezuela or a hotel?
And we're talking about infants. Right. In order for infants to not be stripped of American citizenship and deported to another country they've never stepped foot in, they would have to individually hire lawyers to go argue that they are citizens because this policy is unconstitutional.
Or at least in every district, you'd have to because the stakes in that case are, can there be a nationwide injunction? And to be clear, no matter which president has been in power, I have been defending national injunctions because it's crucial for judges in this era to be able to protect people's rights. And that is at stake in this case. And there has been such a backlash, especially among conservatives, against nationwide injunctions that protect basic rights, that I now would not be shocked. And it is shocking that after the Supreme Court heard the Trump administration's lawyers say, we don't really have to follow precedents.
Yeah.
Not only old precedents like Wong Kim Ark on birthright citizenship, or new precedents like judges' rulings, we can just defy them. That's essentially what the Solicitor General said in oral argument. That the Roberts Court said, okay, that doesn't worry us so much that we should just go ahead and send a green light for disobedience in this next case about the removals. So that's why I'm worried now, is that it's obvious that the Roberts Court has not read the room and they've lost the plot.
Jed Shugerman is professor of law and Harry Elwood Warren Scholar. Do I have that right?
I'm the Harry Elwood Warren Scholar.
Sorry.
Yeah, that's it.
I have two different kind of scholars.
Okay.
Okay.
It's the other one.
Okay, it's
Harry Elwood.
Okay.
Warren. Yeah.
Sausage getting made, folks. Jed Shugerman is professor of law and Harry Elwood Warren Scholar at Boston University School of Law. His forthcoming book, tentatively titled A Faithful President, The Founders versus the Originalists, questions the Roberts Court's historical evidence for its theory of unchecked and unbalanced presidential power. Thank you, Jed.
Thanks everyone, and thanks Mark for having me. I appreciate it.
I'm now going to read the outro, but it's not the actual outro because we still have to get to questions. More sausage. Hold, please. And that is a wrap. Thank you so much for listening. Thank you so much for your letters and questions. You can keep in touch at amicus@slate.com, or you can find us at facebook.com/amicus podcast. For those of you who couldn't join us in Boston, Dahlia and I taped a Rock'em Sock'em Opinion Palooza bonus episode where we talked about the seismic ruling against Trump's... Sorry, hold on. Okay. Dahlia and I taped a Rock'em and Sock'em Opinion Palooza bonus episode. If you want to hear that, you're going to want to subscribe to Slate Plus directly from the Amicus show page on Apple Podcasts and Spotify, or visit slate.com/Amicus Plus to get access wherever you listen. That episode is available for you to listen to right now. We'll see you there. And make sure you subscribe to our newsletter so you can stay up to date on the Supreme Court and beyond with a weekly roundup from us here on Amicus and the jurisprudence desk's latest articles. Go to slate.com/legal brief to sign up for that. There are links to all these things in the show notes. Sarah Birmingham is Amicus's senior producer. Our producer is Patrick Fort. Hillary Fry is Slate's editor-in-chief. Susan Matthews is executive editor. And Ben Richmond is our senior director of operations. Thanks to Katie Rayford, Slate's director of media relations, for her work on this special episode. Extra special thanks to Stephen Davey at CitySpace and the good folks at the WBUR Festival for hosting us. We'll be back with another episode of Amicus next week. Until then, take care. But you don't have to wait until then, because now we have audience questions. I have them right here, and I'm going to start with one that gives me another opportunity to potentially to yell at you, Jed. As a result of Trump, a listener asks, should we now be loving the major questions doctrine?
Yes.
No.
Yes.
No. Explain it, and then I'll explain why you're wrong.
Okay, so first let me... how many people have heard of the major questions doctrine? Okay.
I feel sorry for you.
Okay, all right. So this I have been pro major questions doctrine for a long time. And it is a check on executive power. Now, it was designed to be a check on administrative power, but it is used, and this is a study that Jody Short and I, in an article, demonstrated, is that every time this, okay, so let me describe what the doctrine is. How many people have heard of the non-delegation doctrine? Okay, so I'm going to explain both. All right, so this is complicated, and I'm glad, now I realize just how, I'm glad we didn't go into this whole thing, right, on the podcast. But here, let me give you the presentist moment where how I learned to stop worrying and love the major question doctrine for you. I've been loving it for a long time. The tariffs case, where there was a court that overturned Trump's tariffs on Wednesday. Okay, then it was paused. That overturning was paused. They relied on the major question doctrine because Trump was exceeding the authority granted by Congress to impose tariffs to his friends, tariffs to his enemies, but grant carve-outs to friends. So what is that? So what is the major question doctrine? How did they get there? So the non-delegation doctrine is that the legislative power is Congress's, and Congress can't delegate legislative power or stuff like legislative power to the executive branch. Usually that means don't delegate it to agencies, but it also means don't delegate it to the president because it's legislative power. So it turns out that the Roberts Court is unwilling to totally reanimate this doctrine. So they in the shadow of that doctrine, they say we need to reread statutes to make sure that power was explicitly delegated, right? And if we will read it in light of this rule to make sure that Congress decided that question, if it's a major question. We will let Congress delegate minor questions, but if it's a question of vast economic or political significance, my acronym is VEPS, vast economic or political significance, Congress had to speak specifically to it. Okay, let me give you an example of what's awesome about the major question doctrine. The Roberts Court saved Obamacare with the major question doctrine, okay? Why? Because they said, even if there was this weird textual thing, there was a mistake, more or less, in Obamacare about federal exchanges, where they use the word state when and what Roberts says is, we look at the purpose and the legislative history. By the way, that's not what textuals do, but we look at the purposes and the Siri is, I need to shut my watch down. Okay, so the point is that I even said it on Do Not.
I'm going to seize on this moment.
Okay. Let me just connect the dot, though. The point is that not everything is answered by textualism. Sometimes major questions, we need Congress to decide these things. And so that gets us to the Biden student debt cases. As a legal conservative, I will tell you, I saw this coming. And so I wrote an amicus brief saying that President Biden was using COVID emergency in bad faith, because he would, on the one hand, say we need to extend COVID debt relief, and on the other hand, a day later say the COVID emergency is over, and that was an abuse of presidential power that helped Trump get elected. You want to look back and understand how non-college voters resented the Biden administration? Nothing was weaponized more to give non-college voters a grievance like giving away $700 billion to people with college debt. Right? I think that was a problem. But I also think presidential power, the abuse of presidential power, is a problem by both parties, and the major question doctrine is a check on the abuse of presidential power.
Okay, so you have a whole acronym, vast economic and political significance. So the Supreme Court says even if it looks like this statute seemingly gives the executive branch the power to do this, student debt relief, regulating emissions from coal-fired power plants is another example that Jed surprisingly didn't mention when extolling the virtues.
That's fair.
Of this, the Supreme Court said, actually, we're not going to read the text of the statute to allow what it might seemingly allow, because we, in our infinite wisdom, subjectively believe that Congress did not intend to grant a federal agency the authority to determine this this vast question of economic and political significance. So what 5 justices on the Supreme Court think is really, really important and meaningful, that gives them essentially a free-floating veto over the application of the text of a statute to some kind of regulation that the executive branch wants to enact. Look, I don't really care about student debt relief on the merits. I don't need to get into it. I don't even want to get into the merits of tariffs. But the point is that we should not be disempowering, in my view, Congress from writing broad statutes when everything we just talked about was the executive branch and the courts disempowering Congress in other ways. If we embrace this theory of the major questions doctrine, we are basically telling Congress, sorry, we know you wrote this statute and we know you may have meant what you said, but 5 justices on the Supreme Court don't believe that you did. And so we're not going to allow the Biden EPA to regulate coal-fired power plants in this way. We're not going to allow the Biden administration to relieve. It was $450 billion in student debt, but
a billion here and a billion there.
And really, in my view, take away the administrative state's ability to interpret and enforce what Congress allowed it to do. And so to me, like, look, I get it. I'm all for like making sure that the executive branch doesn't abuse its power. That was 50 minutes of our conversation, but I don't want it to be done at the expense of the judiciary establishing its supremacy over the words that Congress wrote.
Okay, so first of all, you're right about that analysis and how so I'm an originalist in theory, but not in practice. So what I say about originalism is the worst form of constitutional interpretation, except for all the others. Okay, and so why should one? Okay, so I'll say 2 things. I'll also say the abuse of judicial power is the worst kind of abuse of power, except for all the others. If I had to, what are you more worried about right now, Trump or John Roberts? Who are you more worried about? Who comes after J.D. Vance or John Roberts? The answer is J.D. Vance. The answer is J.D. Vance 100 times out of 100, okay? So in our modern America, right, I mean, I don't think the 4th branch is unconstitutional, but I will recognize that we have weaponized executive power, and the most powerful kind of executive power is prosecution, and we're seeing it right now. And but by the way, both parties have a problem with prosecutorial power. That's how we get mass incarceration by Democrats and by Republicans, and that's how we also, by the DOJ has this problem as well. So what I will say is, in terms of this concern that I have about the judiciary, I share it, but the reason why I will side with a judicial power over executive power is that it is the least dangerous branch. It can check the most dangerous branch. And originalism is the way to hold the Roberts Court to some kind of accountability for its ideological assumptions. I may be naive, but I think the briefs we're filing could get some traction if they actually care about historical.
I don't think it's naivete. I think it's just terminal law professor brain. But that's why we love you, Jed. We have like 30 seconds. I have one more question I want to squeeze in. You give us 2 sentences on this. Any thoughts about or signs of whether Chief Justice Roberts might be having second thoughts on Trump versus United States and its broad ruling in light of what's happened over the last 5 months?
Okay, so if I want to be naive and law professor brain, I'm not going to read a decision. I'm going to read what Roberts said about 2 weeks ago, that said that it is the role of the Supreme Court to check the excesses of the legislative and the executive branch. And maybe the 10th justice is now Jay Powell, right? It turns out that it's not the Solicitor General. If they're worried about the Fed, and Jay Powell went out and gave graduation speeches about defending democracy, this is why I'm reading this decision by Roberts and the conservatives as the art of the deal with the devil. They aren't trying to enable Trump. They are trying to bargain with Trump. And eventually, I think they're going to have to set terms to their end of that deal. And I'm going to naively say, I think they're going to do it.
Thank you, Jed. Again, one more round of applause for our wonderful guest.
Thank you.
Big thanks as well to WBUR for hosting us and to the team who put this amazing festival together, including the CitySpace team, Stephen Davey, Amy McDonald, Candace Springer, Avi Nguyen, Chris Barrios, Taylor Beddison, and Deb Sullivan, as well as folks at WBUR, Tanya Erlach, Eva Rosenberg, and Andrea O'Mara. Thank you to everyone for joining us today.